Catherine Delahunty.
I'd just like to take a brief call on the parts of the bill that have been a particular concern to many submitters, and I do want to refer to some of the submissions that I didn't get to hear personally, but I did get to read at the Select Committee. And there seems to be considerable doubt and debate around some of the issues. For example, the definition of terrorism. And it's interesting just to note that there's been no convictions under the Terrorism Suppression Act so far. And Section 5, which has been referred to a lot in relation to this bill of the Terrorism Suppression Act, is defined in a way that the Prime Minister may add organisations to the list of designated terrorist entities. And if he's satisfied that they have carried out a terrorist act, they can go on a list. And so that's quite a broad definition. And if you look at, for example, what happened in the 1980s with the African National Congress when they were fighting against apartheid and they bombed South African military buildings, I would never advocate violence, but are those people terrorists? So it's kind of interesting to see how broad these definitions can be and who will be captured. And a lot of the submitters didn't have confidence that the definitions and the way that these two acts interrelate would actually target people who were genuine terrorists. They felt there was real risk of it being broader. And it's an interesting debate as to whether we should support anyone leaving this country to participate in foreign war. We certainly support soldiers doing it, and some wars where many of us don't see why. So we're not consistent here about who's a good killer and who's a bad killer. And I think it's really important to talk about that as a society rather than just to identify some people for their country's independence as being bad and other people who are fighting on behalf of the New Zealand government as automatically being good. I think these are superficial, which is why we'd much rather have a far deeper examination of this whole topic and rather than this rushed legislation. So also the Human Rights Lawyers Association made important points about Part 2 when they talked about visual surveillance, and they describe it, to quote, as a particularly highly intrusive and impacting heavily on the right to privacy afforded under domestic law and international convention. And so they believe that before such powers are enacted, the SAS must show the need for them, i.e. the capability to perform existing duties is impaired by an inability to carry out such surveillance. Now, I think that's quite an interesting phrase. The capability to perform existing duties is impaired by an inability. So we haven't seen the proof of that. I don't know whether it was described at the Select Committee, but certainly these submitters feel that it wasn't addressed and that there's a whole issue around why create a law for something when actually the SAS already have the capability to do a great deal of things. Although capability is an interesting word after many years of having been surveilled by the SAS and having read many reports about the SAS, I'm not sure what they've ever done that seems particularly effective in this country. Maybe there's a whole seething mess of 60 years or so of dissenter behaviour that desperately needed to be followed, but a lot of it seems to have been fairly bizarre, to put it bluntly. So not only the Human Rights Lawyers Association, but Amnesty International also talked about the issues that are covered in Part 2 around surveillance and had some real concerns about those. Also, they had concerns about Part 1 in terms of amendments to the Passport Act. But the statement, which I wish to quote, is that compliance with all human rights while countering terrorism represents a best practice because it not only is a legal obligation of states, but it's also an indispensable part of a successful medium and long-term strategy to combat terrorism. So compliance with human rights, with the Bill of Rights, with all forms of international conventions should be absolutely fundamental. And we don't think that this Act has addressed those issues. We think that it's incredibly serious. And when Amnesty talk about the Special Rapporteur on the promotion and protection of human rights, Martin Sheenan, probably pronounced that wrong, Sheenan, the Special Rapporteur, he talks about the promotion and protection of human rights and fundamental freedoms as being really vital to actually preventing terrorism, because we model and we stand up for human rights and we acknowledge the human rights of people who could potentially become our enemies. And that's why it's so important that this Act is not pushed through and with such a hurry when these groups, these very, very committed groups with civil liberty expertise, actually raise really serious issues about the tests and about the conventions. Mr Chair.
I'm going to call Tracy Martin.
I want to take a quick call on